Welcome back. A retired Court of Appeal judge has criticised his former court for upholding the convictions of the directors of Lombard Finance. The directors, including 2 former cabinet ministers, were convicted of making untrue statements to investors. The Court of Appeal has upheld the conviction, but given the men leave to appeal their home detention sentences. But Sir Edmund Thomas says the directors have suffered a miscarriage of justice. He's with me now. Good morning, Sir Edmund. Thank you for coming in this morning. Why do you think the directors have suffered this miscarriage of justice?
On 2 broad grounds. The first one being that the finding that the prospectus was misleading is based on omissions and nothing actually said in the prospectus. Everything in the prospectus was true. Now, I've read the prospectus and there is a great deal of information in it, and many senior lawyers consider it to be a very, very detailed prospectus.
Right.
And the second ground is there is a defence that if they had reasonable grounds to believe that the prospectus was true, then they're entitled to an acquittal. I think there is no doubt that they should have been entitled to that acquittal. Because
they were found guilty of putting out a misleading prospectus. And I think that it was deemed to be untrue in 3 respects: lack of reliable forecasts, no reference to the concerns at the time of liquidity, and it understated the risk. And do you say that's not the case?
I do indeed, because the prospectus actually spells out that if there was to be a collapse of the property market, investors would run the risk of losing their investment.
You say the court has been swayed by public opinion. I mean, surely the court is above this. That's what we're always told. Yes,
and for the most part that's very true, or I'd like to think it's true. The courts or judges do reflect public values and public considerations, and that's probably a good thing. Judges are not elected, and we would not want them to be distant or apart from the public. On the other hand, they have to stand aloof at times and not be swayed by any public clamour. And you will be well aware that there's considerable pressure here for the directors of any finance company that failed to be punished.
Surely, though, the buck had to stop somewhere. And does it not stop with the directors?
Undoubtedly, the buck stops with the directors. But a finance company, can undoubtedly fail for reasons that are nothing to do with the company or the director's control of the company. And this was the case here. It was a bank lock-up in February, March of 2008 that was the cause of the collapse. This company was a very well-run company. The directors found to be honest. The judge found that they genuinely believed that the prospectus was true. There was no complaint about them being negligent in any respect, no complaint about mismanagement. And the governance of the company couldn't be faulted.
There are many, many people who would disagree with you.
Yes, of course, and I understand that, and I have a great deal of sympathy for the investors who lost their life savings. I mean, that is a disaster. They were probably living on the interest, and now they've lost it. I mean, if I had been sitting, I would have struggled with that. But ultimately, the collapse of the company had nothing to do with the charge before the court. The charge before the court was that the prospectus was misleading, and in my view, it's quite clear it was not.
You said if you were sitting, you would have struggled with that.
Oh, you have to. I mean,
well, that's perhaps what you're suggesting now the court has given into, that pressure, that struggle with people losing their life savings.
Not consciously, no. I wouldn't say they're consciously given into it at all. But no judge can be so far removed from the public as to be indifferent as to what the public are thinking and what the public require, nor should they be.
How do you deal with that then, as a judge?
By strict intellectual rigour. I mean, at some point you have to come back to the fact that this charge had nothing to do with the collapse of the company. It was related to whether or not the prospectus was misleading. And on the basis of the Court of Appeal's decision, even if the company hadn't collapsed, you would have had to say that the prospectus was misleading. In a way, it almost appears as if the directors of this company have been punished for the fact that the company collapsed. To use your phrase, the buck stops here. In the article that I've written, I say very early on in the article, if you cannot accept that a company or a finance company can fail through no fault of the directors, read no further.
Do you think it was further influenced by the fact that 2 of the directors were former cabinet ministers?
Possibly. I don't think so, really.
They were men who came with a profile and a history.
Yes. That wouldn't have influenced me, and I doubt whether it would have influenced anyone on the court.
OK, the Attorney-General says that, there's a convention that retired judges don't comment on court judgments. Yes. So why are you choosing to break that convention, in essence?
I have conceded that there is a convention, but that it's not an absolute rule that you don't comment. The Attorney-General is saying there is an absolute rule that once you're a retired judge, you can't write an article criticising a court decision. I think that in the circumstances here, I was justified to write the article. My target audience was lawyers and legal academics. It just happens to have worked out differently.
The media picks up, don't they?
Yes, you do. And so we've got a situation now where I felt very strongly that these directors did not deserve to be convicted. It is a grievous miscarriage of justice, and therefore I felt that I should write the article.
You have been critical in the past of judgments, and by that I also refer to the Ureweras. Are you frustrated by our Supreme Court?
No, I'm not. I have a great deal. I really did support the abolition of the right of appeal to the Privy Council, and therefore I have subsequently been very pleased with the way that the Supreme Court has performed. I think it's a good court. I think the Chief Justice is a top Chief Justice.
So
she won't be altogether pleased with me at the moment.
So you feel that the Supreme Court has been what you'd hoped it would be in terms of it as the alternative, the legal alternative to the Privy Council?
Yes, I do. I do. Now, I have to say that there are those in the associated with this Lombard case that feel that the outcome would have been quite different if there were an appeal to the Privy Council. We are a small country, and it's felt that if you could get away from New Zealand and have an issue like this where there is a lot of public pressure determined in London, there's a good chance at least of a different outcome. I'm not certain.
In your opinion, then, how would we improve the system to avoid, as you say, a miscarriage of justice for the Lombard directors? What would we need to do to change that?
You can't do anything in terms of structure. All that can be done is the judges themselves be acutely aware that there is a difference between reflecting the public's opinion and at times saying we are not going to be swayed by the populace.
Are we getting the best people we can as judges, given that, there's some very large salaries paid by some of the legal firms attracting people away from potentially becoming a judge and following that path?
Yes, I probably have a higher view of the judiciary, the value of the judiciary and the worth of our judiciary than the general public. I think judges are intelligent, they are certainly industrious and conscientious. And I'd say that of the 3 judges involved in this Court of Appeal decision. I think that we are getting very good appointments to the High Court, the Court of Appeal and Supreme Court. But at the same time, one has to accept that there are some very, very talented barristers and lawyers who have not gone onto the bench, and that's a pity.
Indeed, Sir Edmund Thomas, retired Court of Appeal judge. Appreciate your time this morning. Thank you.
Thank you.